So last time we began discussing Shell against EPA, which illustrates this three-step notice and comment process for rulemaking under Section 553. Once again, this is informal rulemaking. And so there are three steps, which we've discussed before. One, the agency issues this notice of proposed rulemaking that contains either the terms of this or the substance of the proposed rule or description or the subjects and issues involved. And that's 553B3 right here. And then the second step is the agency gives members of the public an opportunity to provide comments. And this is in 553C, the agency shall give interested persons an opportunity to participate through various means. And then the third step is after they receive those comments, the agency publishes a final rule containing this concise general statement of their basis and purpose. And so that is, as a reminder, informal rulemaking. Formal rulemaking is much more like a formal trial with testimony and cross-examination and things. But this presents a bit of a puzzle because there has to be some opportunity for the agency to amend the rule in response to comments, or there's no point to getting the comments in the first place. Because if you learn something from the comments, you couldn't act on that. But if the agency changes the rule too much, then the rule might get to the point where the public wasn't on sufficient notice of the things that the agency might do, and therefore the things that would be useful for the agency to hear. And I'm now seeing there's chat that I was missing on the dates. That's good to know. I will take a look. And so in this case, in Shell versus EPA, we have a complicated set of EPA rules that are defining hazardous waste. We have two rules at issues in this case. One is this mixture rule, which says if you have any listed hazardous waste, any particular substance that the EPA has already said is definitely a hazardous waste, and then you mix that with anything else or with any other solid waste, then the result is also solid waste, is also hazardous waste. This idea that like, if I'm mixing hazardous waste in with other stuff, the whole thing is then hazardous. And the second rule is this derived from rule where if you have hazardous waste and you're treating it, any residue derived from that is automatically hazardous waste. And so the question here is whether these rules were close enough to the notice that the agency had provided in the notice of proposed rulemaking, that the agency had complied with this three-step process of providing notice, soliciting comments, and then providing the statement of the reasons. And so we just started discussing this last time with Mr. Chapman, Ms. Geckel, Mr. Jordan, and Ms. Tolman. So continuing a little bit on this case before we'll move on to the next one, remind us of the legal test that the court adopted.
The court adopted the logical outgrowth test from this. So the final rule that the agency makes has to be a logical outgrowth from the proposed rule.
And what does that mean? Like, what does it mean if something is a logical outgrowth?
That means, I interpreted that as meaning that it's like reasonably foreseeable that this would be the final rule coming from the original proposal.
Yeah, and that's exactly what the court says, right? It's something that the public must have been able to anticipate or should have anticipated, right? Which makes sense because if the purpose of the rule is to make certain that the notice provided enough clarity for the public to be able to tell what they need to provide comments on, then if you look at the notice of proposed rulemaking and you look at it and should say, well, it looks like one of the things that is, you know, a possible version of this rule is anything that is green in color is hazardous, right? Then you would provide comments on that. But if you can't tell that, then you would never provide comments on that. And so how does that rule apply here?
So I think you might start with looking at what the initial regulatory language they put forward would be that people were giving notice and comments are. So here the EPA said what they were doing was to identify and quantitatively define all the characteristics of hazardous waste, and then waste generators would be required to assess their waste based on those characteristics. So waste generators would have to test their waste for the characteristics, and if the test failed to reveal a hazard, then they wouldn't have to manage those substances as hazardous. And as part of that, the EPA would list hazardous wastes where it had data indicating that certain wastes exhibited one of the characteristics. They would provide some list, but that was meant to relieve the generators from having to test too many things.
Yeah, so for instance, like the notice says, we are thinking about doing a rule about, if it has this characteristic, if it has this characteristic, if it has this characteristic, then it's hazardous, right? And do they wind up adopting rules that have that form?
No, it seems like what they did instead was EPA came up with a full list of what they considered hazardous and then added on these mixture and derived from rules.
Yeah, they kind of switch gears, right? They instead decide that, rather than sort of create this standard, we're just going to create this bright line rule of, if something was a hazardous waste, but then you like dilute it in sand or something, it's still a hazardous waste, right? And so if someone thought that the tests that they identified were the right tests or were the wrong tests or something, would they have known to provide comments on this? Not necessarily, right? And so they might have thought, well, I don't need to weigh in because my business will be able to comply with this fairly subtle standard because we can do that testing. Whereas like, if they know that they dilute their hazardous waste to a point where it's no longer hazardous and it would pass all those tests, they would still fail under this rule that any hazardous waste mixed with something solid is still hazardous waste, right? So like the group of people who would have useful input on it or would have something to say about it or would have an interest in it is not the same group that would provide comments, right? It's sort of, they're saying we're going to do this and then they go do something different. And so this is the dominant rule. The Supreme Court has actually never expressly affirmed it. This is a thing that the circuits have developed. What do we think of this rule? Is this a good approach? Does it have any problems? Are there any criticisms you would make of it?
I feel like it's a very squishy rule that lets the court kind of pick whichever side they want in a lot of cases. It's not, it's just so hard to, have an objective interpretation of the rule. It feels like they can just take their subjective policy considerations and go with it that way.
So that's one criticism, right? That this is susceptible to judicial manipulation. Ms. Geckel, Mr. Jordan, Ms. Tillman, what do you think? Do you agree with that?
I agree. Can you hear me? I know there was an issue last time.
You're a little quiet and garbled. If you can speak up.
Yeah. I agree with Ben, but I think that there's really no other way to have, I think the ends of this rule, I think they make sense that you want people to be on notice and you want there to be some sort of connection to the rules that they're putting forth and then what rules are promulgated. But again, I think there's a lot of room for interpretation.
Yeah, I mean, that would be kind of the response to Mr. Chapman's points, right? That basically this rule is vague enough that it is susceptible to judicial manipulation, but at the same point, it's kind of the only rule that really addresses the substantive concern we had of this problem that you don't know if that you need to make certain that the comments you get are useful comments, right? And so you need to, like, you can't hide the ball, or at least that's the policy argument, right? That if the agency says one thing and then does a different thing, they won't have gotten the comments that the statute says they were supposed to get. Any other criticisms of it? What about sort of on statutory grounds? Like, is this consistent with the statute?
I would say like not entirely consistent because they can, to a degree, sidestep, like agencies can sidestep notice and comment by simply giving like substantive response comments that would allow the public to foreseeably anticipate their next action, and so they can begin to gray that area quite a bit.
I'm not sure I followed that. Say how that would work.
So right, didn't we said like when the comments begin to kind of come in from one of these proposed notices of rulemaking, the agency can simply kind of respond. And as long as it's like the agency's response, not the public that's like words are determinative, they can go forward and claim that that's reasonably foreseeable that they were going to do this.
I mean, that was kind of the agency's argument here, right? The agency said basically like we kind of, in a sense, updated the notice of proposed rulemaking by sort of giving these vague sort of signs of what we were thinking about doing, or sometimes sometimes agencies will put out a supplemental notice of proposed rulemaking after the notice has gone out based on some of the comments they're getting, where they're like, okay, so we see that all of you think we mean X. What we really mean is X prime, right? I mean, this court doesn't quite bless that, right? Because if you didn't have the opportunity to respond to that, then that doesn't count as part of the notice. But I mean, what does the statute require? I mean, what's the argument that this is fully consistent with the statute? I guess I can pull up the statute again if that would be helpful. So this is parts 2 and 3, and then part 1 is either the terms or substance of the proposed rule or a description of the subjects and issues involved. How does that sound compared to what the court finds is required here?
I mean, the statute doesn't require, by its words, doesn't require that there's need to be a logical outgrowth. It seems like the EPA did do what 3 says, just by the way they gave notice. Like, whether the notice is good enough is not really addressed by the statute.
Yeah, I mean, the notice under the statute here, yes, you can give like the substance of the proposed rule. You could give like, here is our draft text, right? And so that would be the terms or substance of the proposed rule. But you don't have to do that. You can just give a description of the subjects and issues involved, right? Like, I mean, would a notice that says we are considering rules to address the definition of hazardous waste under this statute and ways to, make certain that we protect people from hazardous waste while also permitting industry to operate? I mean, something like that. That's vague, right? But like, could they do something fairly general like that under the statute?
Seems
Theoretically, yes, right? As long as the public can reasonably anticipate what they mean.
Well, I mean, nothing here says they have to be able to anticipate it, right?
Well, but then I think just the notice and comment provision of itself, right? If they can't provision, or if they can't anticipate it, then they can't provide notice or comment.
Yeah, that's exactly the defense of this as a statutory matter, right? Like B, the notice of proposed rulemaking requirement, pretty vague. But C says you have to have an opportunity to participate in the rulemaking through submission of written data, views, or arguments. And the argument would be something like, if you don't really know what they're thinking about doing and you can't anticipate what they actually do in the end, you don't have a meaningful opportunity to participate by submitting written data, views, or arguments, right? That if they just say, like, we're considering hazardous waste and the definition of hazardous waste, then that's so vague that your opportunity to comment is illusory. And so that would be the defense of this fairly demanding test, right? So last question before we'll turn to Portland Cement and American Radio Relay League. What is the remedy here?
Well, the court
Or
says
the-
at the end of the opinion that they could use the good cause exemption in 553 to get around this altogether.
So so they can use that to get around what?
They can use that to get around the foreseeability test or the logical outgrowth test.
So how does that work? What's the mechanics of that?
So it says that like when the agency finds that it's like impracticable or contrary to public policy, then they can just like circumvent the logical outgrowth test altogether. And it seems like the court was kind of recommending that they do that in a way.
Mm-hmm. Yeah, I mean, it's a pretty strong hint, right? But that only comes about after what else has happened. So this is a review by a court of an agency action, and under 706, what are the things that the court can do?
They can hold it unlawful or set it aside.
Yeah.
Or they can relatively rarely compel the agency to actually do something else.
Yeah, and this is not that, right? This is, they are saying what the agency did was unlawful, and therefore they set it aside. So it's like the agency never did this whole process, right? And so they never did the notice, they never accepted comments, and they never put out the final rule. There is no rule, essentially, right? All of that is struck from the record. And so if they want to use the good cause, it's a new agency action, right? Like after they get this opinion, the EPA would have to conclude and, you know, do whatever procedures come along with this, that we have to reenact these rules under the good cause exemption as interim rules and then redo the notice and comment to do them again in the final version, right? This is the standard remedy in judicial reviews of rulemaking here, that the court basically just like, the only thing the court really can do is, other than compel action, which is very rare, like we said, but if they found that the agency screwed up in some way, the only thing they do is vacate the rule. And so the agency basically has to start over. They can't say, well, the rule didn't provide enough notice of, or the notice of proposed rulemaking didn't provide enough notice of this piece, and so we're going to rewrite the rule slightly to make it what they did provide notice of, right? That's not something that the agency, that the court can do under 706 or under, Chenery 2, right? And so this is one reason that rulemaking can take a decade or more, right? Because often, if you have a complicated rulemaking, you'll probably have to budget on doing it 2 or 3 different times before the courts will approve of it. And so this means that, for instance, if there has been a turnover in the agency in the administration in the meantime, and the new agency is not interested in reenacting this rule, they can just sit on it and the rule will go away. And this is a good example of the kinds of uses that the statute includes the good faith exception for, where the idea is the public interest does require some kind of hazardous waste regulation. And so they can use that exemption to try to protect the public from, ingesting hazardous waste. Okay, so any questions on this case before we turn to Portland Cement and American Radio Relay League?
When you see those kind of rules being vacated, is it quite common for the agency to walk away from them entirely, or are they generally redone through notice and comment, like as a practical matter?
No, both are relatively common. And it's not always because there's been a political change. Sometimes it's just, we no longer conclude that this is a good use of our time and our limited, staff. Or sometimes it will be that the court has, when we get to hard look review where we will see the court reviewing like the policy making by the agency. Sometimes it's the case that the agency or that the court has limited effectively what the agency can do in a way that the agency no longer thinks it's worth it. So walking away is relatively common, but like when we read State Farm in a week or two, that's a case where the court struck down an action that was getting rid of a rule, and that was a rulemaking that had been in progress for something like 20 years. And so that one they repeatedly went back to in the face of multiple judicial decisions. And so that happens sometimes too.
Thank you.
Any other questions? Okay, so thank you, Mr. Chapman, Ms. Geckel, Mr. Jordan, and Ms. Tolman. So let's turn to Portland Cement and American Radio Relay League, which are two cases about agency duties to disclose studies on which it is relying in a rulemaking. Okay, so for this one, we've got Ms. Deneen, Mr. Garrett, Mr. Keller, and is it Ms. Rieger?
Rieger.
Rieger. And Deneen is close to correct?
Yeah, that's correct.
Okay, thank you. So let's start with Portland Cement. So what's going on? What's the agency in the statute?
The agency is the EPA, and the statute is Section 111 of the Clean Air Act.
And so what does that statute give? What is the regulatory action here? Or what does Section 111 do?
I think it gives the administrator of the EPA power to promulgate rules based off standard performance for emissions.
Yeah, this is part of the Clean Air Act regulating air pollution, right? So Section 111 gives the agency the authority to regulate various kinds of sources of air pollution. One of them is stationary sources. What's a stationary source?
I'm assuming a plant or a facility that doesn't move.
Exactly, right? It's a factory or a power plant or something like that. As opposed to cars or planes or something like that, right? That's the other major kind of source. And so they put out rules for new or upgraded Portland cement plants. Apparently Portland cement is a type of cement. I did not know that before this case. It's not a city name, it's a type of the material. And so what's the process of putting out that regulation? Like, what was the procedure the agency went through?
So the agency used the rulemaking process and specifically went through the informal rulemaking process of providing notice and allowing individuals to comment and so on. But the court's main issue was the fact that they did not provide all the studies that they were using to for the secretary to promulgate the decision in the action, and provided it following the commentary period.
So what's the timeline of that? Like, let's get specific about what exactly they did.
Okay.
I think you can propose the rule, and then you have comment, or you have to allow for comment, and then you have 90 days to actually promulgate the rule.
But when did they do those things? I mean, in this case. Yeah, go ahead.
December 16th, 1971, if that's what you were asking.
So what did they do then?
That's when they adopted the regulation for the standards of performance.
Yeah, I'm going to pull up I'm going to share a window and we're going to draw out a timeline, right? Okay, so everyone can see this?
Yes.
So they adopted the final reg in December 1971. What happened before then? When did they do the notice?
It was first proposed August 3rd, 1971.
Okay, so they put out, or they do the notice of proposed rulemaking. And what was in the notice?
I think there was one test, and then there was a document titled "Background Information for Proposed New Source Performance Standards." That's
So
what they were saying they justified.
Yeah, so they put in the background info that explains testing and, you know, discloses most of the data, right? What they didn't do was what? Or I guess what came after the final rule?
So they provide, and then they also provide the standard in which the EPA will use in August 1971. But the key part they missed was so they had a standard of 0.3 pounds per ton of feed. And the test that was used to back up that specific number was not provided till after the final regulation was adopted.
So basically they give like, here's the rule we're going to use. Here's the standard for what counts as air pollution or not. And they say, here's like the background info and the testing we did, and here's the data we gathered and stuff like that, right?
Yes.
Sounds like a pretty detailed notice of proposed rulemaking. So what happened after 1971?
All right, and then mid-March 1972, in a supplemental statement filed, they provide the proposed standard, which was based on principally on the particulate levels of the control fabric filter, which I don't know exactly how concrete is produced, but I assume the fabric filter is a part of this whole regulation.
It's part of what they're doing to like filter the air as it's coming out, right?
Correct. And then it said, aside from a summary test results were not made available until mid-April of 92. Or 72, sorry, mid-April of 1972.
Yeah, so we've got this supplemental statement. What is, so why did everyone, when they saw that supplemental, go, hey, wait a minute, what the hell?
Because it provided a different standard than the standard that they were initially proposing before. And it didn't back up, it furthermore didn't back up what they were stating.
Well, I think they also proved that the first test was erroneous.
Correct.
How'd they do that?
I think they recreated the test based off the methods provided.
Yeah, so I don't think it's a different standard, right? Because they had put out the final reg in December, so it's not like they can change it after that, right? I guess, except that to the extent it's a standard for the testing, right? But like, most importantly, like they referenced 2 more tests, right? That they hadn't mentioned before. And like a different testing method, right? This revised particulate test. And then in April, they finally provide that data.
And furthermore, they note that the test was done prior to the final regulation. So the agency, they know, had the information prior to even the final adoption of it in 1971.
Yeah, right? So basically they kind of hid the ball a little, right? Or at least that's the anti-EPA interpretation, right? This idea that like when they put out this notice of proposed rulemaking, they disclosed some of the info they had, but not everything, in a way that if this was the critical test that would have showed that their regulation was bad, would be a problem, right? So I guess the first real question then is like, okay, but this is the EPA using more process than Section 553 requires, because they did, you know, multiple rounds of notice, including these supplemental statements, and, you know, they got more than 200 comments. So what's the problem?
I don't think there was time to comment on the second portion that was disclosed late.
That's the problem, right? That the agency never had or that the commenters never had an opportunity to provide comments on these other 2 studies. And why would those comments be important?
Well, especially in this case, the test kind of the second test kind of proves the first test was erroneous. So
Yeah, right?
part of it.
Go ahead, sorry.
I was done. Go ahead.
So basically that like the agency never had a chance to get comments pointing out how flawed their methodology in the initial rule was. And so what's the rule that comes out of this case, or the holding, or what's sort of the key takeaway from this case?
Yeah, I don't think you can promulgate rules on inadequate data.
What does inadequate data mean?
Well, I think they relied on the first test that was proved erroneous to propose the rule, and then promulgated it before the second test came out. So, I mean, you'd have to have, so, it's almost like they're trying to strengthen their rule by providing the second test.
So this is like the last sentence of the opinion, right? And the first note basically says this last sentence has become the doctrine that every circuit applies. It is not consistent with the purpose of a rulemaking proceeding to promulgate rules on the basis of inadequate data or on data that to a critical degree is known only to the agency. And so like the data has to be meaningful. It has to be inadequate to justify the rule, or the disclosed data has to be inadequate to justify the rule. And so if you have data that shows that the rule is bad, you would have to disclose it. If you have data that would be the essential data to understand the purpose of the rule, you have to disclose it. If you had data that turned out to be irrelevant, maybe you don't, because it is not the basis of the rule and it is not, you know, to a critical degree. But this is sort of the idea, is that you have to disclose everything that is important, right? Consistent with 553?
I mean, I think the next case, Kavanaugh says it's not.
But the other two judges say it is, right?
Professor, wouldn't it just be the same argument as before, that if this was critical to the rulemaking and the public didn't have a chance to comment on it, then the public didn't have a meaningful opportunity to participate in the rulemaking?
Yeah, it's very similar to the logical outgrowth test, right? The idea that on the one hand, section 553B sounds like it's a pretty general requirement, right? This idea that you can just provide a statement of the topics that you're interested in, right? And that doesn't sound very demanding. But on the other hand, 553C says you have to give the public an opportunity to comment. And if these little details are really important here, the public needs to know them or the opportunity to comment is meaningless, right? And so it's sort of subject to the exact same criticism as the logical outgrowth test, that this is really easily manipulated by courts if you want to strike down a rule, right? You can imagine a lot of nitpicky complaints about the notice not disclosing some minor detail where the agency is like, no, that doesn't actually matter. And the court's like, well, it sounds to us like it matters because the industry says it does, right? And so it's almost the exact same policy argument, right? Of making a quick, easy rule that agencies can efficiently follow, where you have to disclose kind of generic details, or not, sorry, generic description of what you're thinking about. And then if the agency, or if the commenters have a problem, it's on them to figure out what they have to talk about, right? Versus, but then you don't have a real meaningful opportunity to comment. There is one additional protection here. You have to show prejudice. So you have to make a plausible argument that you suffered some kind of harm from not having the study. So this was decided in 1973. 5 years later, Vermont Yankee comes along and says, the DC Circuit has seriously misunderstood everything about the APA. even though they are the expert circuit in it, right? Like they don't understand that you're not allowed to make shit up and require the agency to follow all sorts of process that isn't in the statute itself. And so does this Portland cement doctrine survive Vermont Yankee? So that's the key question in American Radio Relay League. What's the background here? What's the agency in the statute and the regulatory issue?
I mean, the agency's the Federal Communication Commission.
Mm-hmm.
I
And the
didn't
statute is there's a bunch of statutes, right?
Okay.
But they have the authority to regulate radio spectrum generally. And so what's the regulation here?
So it's involving the prevention of harmful inferences from licensees to access various radio emissions.
So harmful interference from doing what though?
I thought it was the like taking over of someone else's kind of like radio frequency.
I mean, kind of. So it's access broadband over power line operators.
So is it broadband internet that's going to interfere with radio transmissions?
Broadband internet through what kind of broadband though?
It says over power lines.
So this is a thing that has never really taken off as a big thing, right? But the idea was that like power lines go everywhere, right? Like we did the whole rural electrification project. Like there are more, the network of power lines is more comprehensive than the network of phone lines or cable lines or something like that. And so if we can figure out a way to use power lines to transmit internet signals, right? Or telecommunications signals, then that is a useful use of this infrastructure that already exists. We don't have to like build new lines, right? And so there are ways of doing that where you are sending a radio frequency signal over the power line. And so they were doing regulations to, do safeguards to prevent this from interfering with other radio frequency signals, right? Like the idea is that if you have a power line sort of running near a cable line or something like that, if you start putting electromagnetic signals on the power line, because power lines are high power, that might cause more interference with nearby signals. And so like the phone line might be bad, right? Or something like that. Or it might just interfere with like ham radio operators or et cetera, right? And so what's the challenge to this?
The challenge is based on the fact that the commission failed to satisfy the notice and comment requirements of the APA.
So it's a procedural problem with this, right? Brought by American Radio Relay League. What is American Radio Relay League?
I think it's a union representing radio operators.
Yeah, it's sort of a organization that runs like events and programs and stuff for amateur radio people, right? Like, the first sentence of the case talks about how they petition on behalf of licensed amateur radio operators, right? And presumably their real interest here is not, well, you didn't follow 553 B and C, right? Their real interest is they want to like shut this down, or at least, shut it down to the degree that or, you know, change the standard so it won't actually interfere with their activities, right? They're worried about this FCC regulation is going to screw with amateur radio, and so we're trying to get it vacated. And their argument is that the agency didn't comply with the APA. And so what was the problem with what they did in terms of the APA? What was the lack of compliance, or what was the violation?
I think they redacted portions of staff reports and then other pages from studies that relied on.
So they didn't disclose because they redacted these scientific studies, these 5 studies about like field testing of, if we actually do this, if we send internet traffic on power lines, what are the effects on nearby, you know, radio frequencies, and to what degree is there interference, right? That's the tests. They did these scientific experiments to see, is this causing problems or not? And the court winds up agreeing that failing to disclose these things is a violation of the statute. So what's the statutory basis? What's the violation?
Wouldn't it be based on the USC number? Wouldn't it be 553C, lack of notice?
Yeah, this is the 553C argument again, right? That like you have to give interested parties a reasonable opportunity to provide comments, and you can't provide comments if you don't know what the agency actually knows, right? You can't have a meaningful opportunity to present relevant information if you don't know the information that the agency has determined. And so this violates 553C because you don't have a meaningful opportunity to provide comments, and therefore 553B because the notice didn't give you the basis to provide those comments, right? And so this is the court once again accepting and sort of re-embracing the doctrine that 553, even though 553B is pretty vague in terms of what you have to provide, it seems not very demanding. This is the court reading it to require quite a lot, right? You have to provide all of these scientific studies. I guess I can pull down the timeline from the last case. Sorry about that. And so, you know, this is the court saying in this debate about, do we take the general, not very demanding read of 553B, or do we take the read of 553C saying you have to take all of these comments to give a pretty demanding version of 553B, and siding with the pretty demanding version, right? This is a rare case where we have 3 opinions. This is actually reasonably common in the DC circuit because it's not a very busy court a lot of the time. What are the other 2 opinions arguing? So what does Judge Tatel think first? And note that Judge Tatel signed on to the opinions, right? So Judge Tatel is also agreeing with the 553 holding.
He tries to call it arbitrary and capricious and says the court, as a result of the agency action, the court's ability to perform its review function was not able to be met because all the data was not provided.
So this is a second statutory argument, right? One is that 553 says you have to have a notice. You have to have notice and an opportunity to provide comments. And so if you don't know what the scientific studies are, you can't provide comments. What's the second statutory justification here? Like what is Tatel's, what else is Tatel pointing to?
706.
And so this is basically the Overton Park argument, right? That you can't review what the agency did if you don't have the full record. And that includes the studies that aren't redacted in the notice, right? What do you think of that argument?
Definitely weaker, because I don't think I don't think the agency's action following the giving of the information would be considered arbitrary and capricious, but the fact that they redacted it, one could argue could. So I think it's a little more wishy-washy than the notice argument, which is very factual and objective.
Yeah. Why? So it's wishy-washy. What does that mean? Like, what is 706 says? What about the record?
So it specifically states about arbitrary and capricious in the record.
But also, so arbitrary and capricious is one of the reasons in that list that the court can overturn it.
Yes.
But there's also, so Overton Park isn't based on that. It's based on that last sentence, right? Does anyone remember what that says?
The court gets to review the whole record or the parts that are like specifically cited by one of the parties making an argument to the court.
It's about the court reviewing the record, right? And so what does that say about the notice of proposed rulemaking? I mean, pretty much nothing, right? Because the notice is what you tell people to provide comments. The court is later, and in Overton Park itself, like the court rejected the idea that they had to disclose this to, and in Vermont Yankee, that they have to disclose this to the parties, right? They have to disclose it to the court in litigation, but that doesn't mean you have to make it available to people earlier. So they could have redacted those studies in the notice of proposed rulemaking, but then gave them to the court and been perfectly fine under 706, right? So not as strong an argument, although maybe a nice little supplement to the 553 argument. And then we have Kavanaugh, who dissents saying basically all of this is a violation of Vermont Yankee. So first, just rephrase that argument so we're sort of all on the same page on what it says.
I think he says Vermont Yankee rejected freeform interpretation of the APA not rooted in the statutory text, and you can't find the outcome of Portland Cement in the statutory text of 553. So basically the power is with Congress and the agencies, not the court, to decide on proper agency procedures.
Yeah, Vermont Yankee once again told courts, you can't add stuff to what the APA requires, right? Like the APA is one of the 4 exclusive sources of procedural requirements. Again, the APA, the Organic Act itself, the Due Process Clause, and the agency's own procedures, right? And this Portland Cement doctrine of you have to hand over all the studies is not a thing required by 553B, which is a pretty loose requirement. It says that you have to make available, or you have to disclose to the public the terms or substance of the proposed rule or a description of the subjects and issues involved. That doesn't sound like every scientific study you have done, right? And so the majority, by maybe zealously or overzealously enforcing 553 to get more procedure from agencies, is at least in tension and maybe a direct violation of Vermont Yankees' fundamental premise that this was all Congress, not the courts, right? And so Kavanaugh would overrule Portland Cement entirely under Vermont Yankee. But he had 1 vote, not 2, right? Last question before we'll turn to Nova Scotia. So like the last case, like Portland Cement, there's this prejudice requirement. So what's the need? What did the league have to show to prove prejudice?
I think it said that all you had to do was have something useful to say about the studies and then mount a credible challenge, given the opportunity to comment.
Yeah, that you have to have something useful to say, that you have to be able to mount a credible challenge. Is that a demanding standard?
No.
And so on 583, middle of the page, quote, as suggested by the league, the partially redacted pages indicate that a study's core scientific recommendations may reveal the limitations of its own data, and that its conclusions may reveal methodology or illuminate strengths and weaknesses of certain data or the study as a whole, right? Are they saying anything about these studies, or is that something you could say about any study?
You could argue that comment about any study. It wasn't just specific to this case or that study that was provided in that situation, because it's like studies' core scientific recommendations.
So the redacted info is stuff that they don't know, right? Like they don't have access to it, it's redacted. And the American Radio Relay League, without knowing what is under the redactions, says that the redactions may reveal the limitations of the data and may reveal methodology or illuminate strengths and weaknesses of the data or of the study as a whole. That seems like any time you had a scientific study, if you redacted part of it, you could say, well, the redacted stuff may tell us like limitations about the study, right? And so then the league points to a little more specifics than that, right? Like they point to some headings that say like, you know, here's information arguing for caution on this, right? But they didn't really have anything concrete to point to other than, well, they redacted stuff and that's probably the stuff that would tell us why these studies are bad. Do you think that's enough to demonstrate prejudice?
I mean, I think if the redacted material has methods of how they've like completed the tests, then I think it would be enough. Because if I'm on the other side, I would probably want to discredit or, I don't know, take the, I would want to discredit the test basically. So you're going to have the methods on how to rerun the experiments or the tests.
Mm-hmm. Right. But is it prejudicial if they don't have that info? Like, wouldn't it only be prejudicial if it turns out that they have that the studies have problems?
I believe it would be prejudicial because it would discredit the merits of the test. If any individual doesn't have the ability to rerun the test, then how can you provide the merits of the test in the first place? Or I could just make up anything.
That's a good point. Maybe the standard isn't, is the test actually problematic, but does it have inherent credibility? And if you're not revealing stuff, it inherently has less credibility, right? And that would be sort of the argument on the challenger side here, is that like, we can't argue with certainty that if we had this data, we could challenge the rule and show why the rule was bad, because we don't know what the data is, right? Like, it's hard to demand more than this demands if we don't have access to the stuff we would need to prove real prejudice, right? Like, it's hard to say we can prove this rule is bad if we don't have the stuff that we would use to prove the rule is bad. And so it kind of has to be a relatively non-demanding prejudicial analysis. Anyone have a counter argument? Any reason that like this is too demanding of agencies?
How do we know all the data it has? There's a lot of data in an agency. Is it just an excuse for a court to like stick its hand in and like fish for data?
Yeah, right? Like, presumably a diligent, competent agency is going to have a shitload of data on anything it's about to do, right? And the agency knows much better than the court does, probably better than American Radio Relay League does, whether this data is relevant or not. And if you say the challenger has to be able to show problems without, like, that they have to basically be able to access anything that might be useful, then you're basically saying agencies have to disclose like everything they're using, right? And that's going to make rulemaking harder and more expensive and more of a pain in the ass. And the agency probably knows what they're doing, but on the other hand, the agency might have an incentive to hide stuff, right? And so maybe this is necessary. So any questions on this before we turn to our final case on kind of the mechanics of notice and comment rulemaking?
So one quick question.
Yeah,
so involving the 706 versus 553 distinction.
Mhm.
So the court can get all the information upon request, but the people involved in the commentary are not given, don't have to be given even all the information that was used to make that rule. That's it.
I mean, sort of. So 706 says the court must review the record or the parts cited by the parties, right? But it's not a rule of like discovery. So it doesn't say like the agency has to submit the record in camera to the court. And the court probably wouldn't know what to do with it, right? Like in litigation, the reason we have the adversarial process is both sides can look at the stuff and point out the stuff that's relevant, right? And so it really is only going to be useful if, as part of that litigation, the parties can, or the challengers can obtain the information in discovery. And, you know, in this case, like they didn't, right? Because the court talks about how, you know, the league is only suggesting that the partially redacted pages might include stuff. Like it's clear that the Radio Relay League has not received this stuff. And we don't have any reason to think the court has, right? So 706 only applies once you're in litigation, but it doesn't follow from 706 that like the agency is going to automatically hand everything over to the court. It's more that like, if as a matter of the normal civil procedure of a lawsuit, the information hasn't been handed over, then that is a reason that the court can't evaluate it and therefore would like vacate it under Overton Park, right? And so because of Overton Park, because of 706, the normal course of events is that agencies try to hand it over from the beginning, like put it in the notice. But that's not technically what 706 requires. Does that make sense? It's a little complicated answer, but it's kind of a complicated question, I guess.
Yes, thank you.
Any other questions before we turn to Nova Scotia food products? Okay, so thank you, Ms. Deneen, Mr. Garrett, Mr. Keller, and Ms. Rieger. So this is our one case on step 2 of notice and comment rulemaking, or on step 2 and 3, I guess, of receiving comments and then considering the comments and incorporating them into the final rule, right? So under the statute, all step 3 requires is that the agency incorporate in the rules a concise general statement of their basis and purpose. And so again, that could be like step 1, something that is not very demanding. But as we see, the courts are fairly demanding on it. So our big question is going to be what that requires in practice. And so for this, we've got Mr. Lewis, Ms. Sachs, Mr. Tylock, and Ms. Vemaganti. Did I say that right?
Yeah.
Thank you. And I guess anyone else, did I mispronounce your names? So what's going on here? What's the regulation? What's the agency in the statute?
I think it's the FDA who made these time, temperature, salinity requirements that like regulated how well fish have to be cooked before they're served or sold.
So FDA regulation on basically smoked fish, right?
Yeah.
what's the statutory basis for it?
I believe it comes from the Food, Drug, and Cosmetics Act.
Yeah, and so section 342 of that act does what?
Ensures that, I guess, food is not adulterated, so like it's not like contaminated.
Yeah, so under the Food, Drug, and Cosmetic Act, the agency can regulate adulterated foods, right?
Mhm.
And 342 gives the agency a limitation on what foods are adulterated. It said food shall be deemed adulterated if it's been prepared, packed, or held under insanitary conditions where it may have become contaminated by filth or it may have been rendered injurious to health. What's the background here? Like, what led to their concern that led to this regulation?
They found that this fish was prone to botulism or something.
So there was this outbreak of botulism cases in the early 60s, where vacuum-packed smoked fish led to at least 8 cases of botulism. After this happened, the industry abandoned that packaging method and then didn't have any further problems with this. But then in the 70s, the agency decides to go ahead and promulgate regulations to prevent more botulism outbreaks, even though there hadn't been any cases since 1963. And so, you know, the industry's like, well, we already solved this. Why are you getting involved, right? You kind of see why they're annoyed here. So what's their challenge? What's their specific legal problem with this regulation?
I think it was that they had submitted comments because they wanted to work with the FDA about making, you know, the FDA was being very general and broad about all fish have to meet this certain temperature requirement. Food processors were saying, well, that might not be true of all species of fish, and there's other ways around the temperature requirement if we introduce different kinds of salts and other chemicals. So they submitted comments during that notice and comment period, and the agency appeared to just ignore those comments. They never addressed them.
So there's sort of two, I'm gonna state 2 ways of framing that, right? And I want you to tell me whether this is one or both or what, right? One is, we told you in our comments why this is stupid, right? We and other people gave you comments that explained how this would destroy the industry and is not necessary for safety. And you issued a rule that did that anyway. And that is arbitrary and capricious and not consistent with the statute, because it is like, you're just misunderstanding the world, right? And another way of saying that is, we told you in our comments why this is stupid and you didn't respond, right? You ignored our comments. And therefore you didn't comply with the 3-step process under 553. Like, procedurally you screwed up. So which of these is that?
I'm sure they wanted to say the first, but I think it was more or less the second.
So the cases we're reading it is the second, right? This is about what is required in that procedure. We're actually going to see later in the course that the first argument is also an argument you can make. And they also made it here. But that's not what we're reading this case for, so that part's edited out. But keep in mind that distinction between arguing, 1, your policy is bad, and 2, your procedure is bad, right? This is about the procedure here. This is about, we told you why this is bad and you ignored us, not we told you this was bad and you did it anyway, right? Everyone understand the distinction there? And so what were the comments that they're pointing to? Like, what are the comments that the FDA ignored?
One of them was that the times and temperature regulations weren't commercially feasible for the type of fish that they produced, the whitefish species. So there should be like a species specific consideration in the regulations.
Yeah, so your regulations would destroy our industry. They're not commercially feasible. They're not necessary. If you really want to do this, you need to like look at species by species. And who filed the comments?
One of them was filed by a federal agency, the National Fisheries Institute, and there was also the Nova Scotia Food Products Corporation.
So mostly the industry, but also this bureau of the federal government, right? Which is kind of remarkable that like the FDA is ignoring comments from the federal government, right? Nova Scotia here had refused to comply with the regulations, and that caused the government to sue them. This is not the normal procedure. One, obviously that was a huge risk on their part, right? But at the time, the rules for when you could challenge a rule before the agency was enforcing it were very strict. Today, as we'll see later in the course, they are more forgiving. It is easier to do this. So today they would have just sued, right? But at the time they couldn't for procedural reasons that don't really matter here. So what's the statutory basis for their challenge? Like what is the exact piece of the statute that was violated according to the challenge?
They challenge under 553C the requirement for a general concise statement because the comments that they provided weren't incorporated or addressed or responded to in that general concise statement.
So, I mean, that sounds at least facially a little implausible, right? Because a concise general statement doesn't sound like respond to every comment you have. So why do they have to respond to the comments?
Well, one of the reasons that the court says that they don't have to respond to every single comment, but they do have to respond to comments that are of a cogent materiality.
Mm-hmm.
Otherwise, there would be no procedural safeguard to prevent agencies from just making arbitrary decisions.
But I mean, why is it a violation of the statute for the agency to just make an arbitrary decision as long as it's like consistent with the underlying Organic Act and they go through the process and everything? Like that is reading a lot. That is reading a lot into a requirement that you give a concise general statement.
Also an issue though too of where there needed to be some record that a court could then later look at to decide how exactly they interpreted these comments. And so if their statement didn't include anything about that, there would be no record to confer with. So
that's a problem under the 706 rationale, right? Very much so. That like, it's hard to analyze, does this policy choice make any sense if you can't tell why the agency made it? But still, like, if Congress is considering enacting a bill and people testify in hearings, this would be bad, it would destroy the industry or whatever, and Congress votes to adopt it anyway, like, we don't say they can sue Congress for ignoring their testimony, right? So why do we do that here?
Well, otherwise the whole comment making process would be futile. And the court says like that agencies aren't Congress and they don't have the legislative authority the way Congress can just ignore and make laws. Like agencies don't have that power. So there's like public interest in employing these safeguards.
So sort of two different points there. One, that agencies don't have like the lawmaking authority under Article 1 of the Constitution, right? They've been delegated some limited power, but that delegation is subject to these requirements under 553. And so maybe it's consistent with the constitutional separation of powers to interpret the agency's power fairly narrowly there. And remind me again the first point you said.
I think just that it would otherwise render the public input that's afforded by the APA futile and meaningless.
Yeah, that like, if you provide comments and they can just ignore them, then what's the point of providing comments? I mean, how would the FDA respond to that?
If I were the FDA, I would say it wasn't a comment of cogent materiality.
I mean, sure. What else would you say?
I guess you could also kind of go like the Vermont Yankee route, saying that like the statute doesn't require you to respond to anything. So that's like the court adding procedures to what you have to do.
Yeah, they're doing the Vermont Yankee thing again, but like on the policy side of it, right? Like, you know, let's say like you're the lawyer for the agency and an oral argument, the judge is like, but come on, right? Like, you're not even going to tell them why you can't do that. Like, what's your sort of policy response? Maybe there isn't one. Maybe they should have provided comments, right? Or provided responses.
I guess you can just say that like you're the industry expert and you are afforded that discretion, and the APA doesn't say you have to listen to the comment.
Yeah. Like we're the expert agency here that Congress created to consider these things, right? And of course the industry is going to say every comment we make is really important and you have to respond to it. But they're the ones who don't want to provide safe food because it's more expensive. We're trying to protect consumers. We're trying to protect people eating fish, and we're the experts. And why is the court going to trust the industry's word over ours when they have a conflict of interest and we don't? Of course we read these comments, but we are chronically underfunded. Congress doesn't give us enough money to hire enough lawyers to read these comments. And so we read them, we decided they were bullshit, and we ignored them, right? And why are you going to second guess that? Plausible? Like, why isn't that a really strong argument?
Well, I think there's, at least in this case, that requirement that they were trying to enact really destroyed the industry, of them basically saying, look, we have no way of serving this food product because it'll be completely unpalatable, destroyed, whatever. And so you're basically—
well, at least that's what the industry says, right?
Right, yeah. But that is their argument, is that, you know, we really can't sell this product anymore. You're essentially making a rule that says we can't sell our products.
I mean, there's this famous story in copyright law about the head of the Motion Picture Association of America testifying before Congress in the 80s that the Sony Betamax VCR is Jack the Ripper to the movie industry, right? And that he will single-handedly wipe it out, or they will single-handedly wipe it out. Obviously that didn't happen, right? Like, it's really easy for an industry to say, well, if you do this thing that increases our costs of doing business or makes it slightly harder for us or something, it's always going to destroy the industry as far as they're concerned, right? Now, maybe this is a case where that was in fact true, as we saw from them, you know, being willing to operate anyway. But it's hard to say that the rule is, if it really will destroy the industry, we'll look at it closely, when something like that's something that clearly the agency would know more than the court, right? And so why not leave this to the agency? Like, why is that not a really strong argument to get rid of this doctrine?
Doesn't that come back to the same argument that leaves the agency with a lot more discretion than desired? Like, they can make that argument at any point that they use their expertise.
I mean, they can use it at any point, but isn't it strong at any point? Like, what's Like the agency would say, yeah, you should defer to our expertise all the time.
Isn't the argument that Congress didn't say that? They said, we'll defer kind of to your expertise with notice and comment provisions.
I mean, yes, but they didn't say as long as you respond to every comment in detail, right? They said as long
But
as you
then
give
why?
a concise general statement of why you're doing this.
But then why include it at all?
Good point. Like, what's the point of a concise general statement if it really is concise and general, right? You know, and like we do get agencies that sometimes have biases, right? Like it's a little weird that the FDA was trying to regulate this when it appears that the problem they were trying to fix had gone away for a decade, right? So is there a rule out of, oh, I'm so sorry. I did not realize we were over time. I'm so sorry, everyone. In the future, please feel free to yell at me if I'm just going over time like this. Anyway, we will have a couple more questions on this next time, and then we will turn to some more rulemaking cases. See everyone on Wednesday.